Hi, I'm often asked about FATCA client due diligence and CRS client due diligence and the importance of them and how to do them correctly. I teach this a lot, and one thing I've learnt is that it sticks for longer with students if you can give them the context. So this video is about what happens if you don't do the FATCA CDD and the CRS CDD correctly and the consequences of that. You'll see a lot of other themes in here. You'll see not only tax evasion, you'll see money laundering, pump and dump, stock schemes and fraud. All sorts of financial crime. I hope you enjoyed the video, I hope you find it useful, and if you did, please hit subscribe.
A reporting FI does not reduce the cost of its FATCA program by offboarding US citizens or denying US citizens access to new accounts. The thing to understand about FATCA is that it is predicated on the assumption that all customers are Americans unless it has been positively established that they are not US citizens. This happens by actively giving the customer a FATCA status. This compulsory and expensive part of FATCA due diligence cannot be avoided by offboarding US citizens. Every customer is awarded a FATCA status as part of FATCA customer due diligence. All customer financial accounts have to undergo FATCA CDD to be awarded a FATCA status. Once a financial institution has classified its customers' financial accounts with a FATCA status, it has incurred most of the cost of FATCA, which is the classification. Having established that a customer's financial account has a FATCA status that is consistent with a US reportable status, a financial institution simply obtains a W-9, a self-certification, from the customer and reports them. All things being equal, a financial institution would also have to get a self-certification from non-US customers in order to obtain a FATCA status as part of customer due diligence. Having established a US reportable FATCA status for a customer, FATCA reporting is straightforward and relatively inexpensive, relative that is to the expense already incurred in obtaining a FATCA status as part of the FATCA customer due diligence. Hence, it is a myth that the cost of FATCA compliance can be substantially mitigated by offboarding Americans or denying US accounts to US citizens. Furthermore, under the Common Reporting Standard, financial institutions in tax jurisdictions that participate in the CRS must determine the tax residencies of all customer financial accounts, notwithstanding US citizenship or the lack thereof. Hence, denying US citizens access to financial accounts is of no benefit to financial institutions. How did things ever get so far? This video will explain how things got so far by examining FATCA's second indictment word for word. At the end of this video we will examine whether FATCA is good law, how it can be improved, and how this improvement can happen. A second indictment for FATCA. This indictment illustrates more than any other how tax evasion is a predicate offence to money laundering. For those in any doubt that this particular indictment relates to FATCA directly, we need go no further than page 21, where it says the defendants did not identify von der Goltz as such when they opened these accounts at the US-based banks. Instead, the defendants signed IRS Form W8-BEN-E, falsely certifying to the banks that the accounts were not subject to IRS income tax withholding. Then if we go to page 28, because the account was not identified as a US account and no IRS Form W9 was on file with the Swiss bank, no taxes were withheld from any capital gains generated from the sale. Similarly, no taxes were paid on gains generated by the sale because von der Goltz, with Gaffney's assistance as the return preparer, filed a Form 1040 for the 2013 tax year that falsely failed to report this income to the IRS. And for those still doubting that this has anything to do with FATCA, let's turn to page 35. No W8 forms, no beneficial owner signatures, no presence in the US. A defendant here in CC2 informed Client 3 that CC2 had found a bank account that seemed to be exactly what they were looking for. No W8 forms, no beneficial owner signatures, no presence in the US. And then finally, as if to make the point precisely that this does relate to FATCA, page 37. In March 2010, Congress passed the Foreign Account Tax Compliance Act, which imposed additional requirements on foreign banks to search their records for US taxpayers and to report the assets and identities of such persons to the United States Department of Treasury. Shortly thereafter, in an email to Client 3, dated April 7, 2010, copying Brower, Owen stated that with respect to this new law and consequences, the jurisdictions facing more trouble will be the ones with a tax information treaty in force and regularly effective with the USA. Owens further stated that we should not panic as the law would be very difficult to put in practice. as many countries would strongly object. Moreover, Owens advised that if we would like to be completely protected, in essence, no direct bank account or securities investment should be made with no bank whatsoever, in which case insurance policies, life, pension or similar, or real estate direct investments would be the road to take. In our case, life insurance policies, wrapper, would be the path to take. Having established the links to FATCA, let's go back to the beginning of the indictment. Count 1. Conspiracy to defraud the United States. Owens, Brower. The grand jury charges the defendants and associated entities. 1. At all times relevant to this indictment, Ramses Owen Saad, aka Ramses Owen Saad, the defendant, was a citizen and resident of Panama. 2. From at least in or around 1992, up through and including at least in or around 2010, Ramses Owens, aka Ramses Owen Saad, the defendant, worked as an attorney at Mossack Fonseca & Co., Mossack Fonseca, a Panama-based global law firm and entity that specialised in creating foundations and trusts, incorporating offshore companies for a fee, and setting up overseas bank accounts for clients, including US taxpayer clients. Page 2. At all times relevant to this indictment, Dirk Brower, the defendant, was a citizen of Germany and a resident of Panama. 4. From at least in or around 2005, up through and including at least in or around 2017, Dirk Brower, the defendant, worked as an investment advisor for Mossack Asset Management SA, Mossack Asset Management, a Panama-based asset manager company which was closely affiliated with Mossack Fonseca. 5. While employed as an attorney at Mossack Fonseca, Ramses Owens, aka Ramses Owen Saad, the defendant, assisted clients of Mossack Fonseca, including US taxpayer clients, in, among other things, setting up offshore foundations, companies and bank accounts. In so doing, Owens worked closely with Dirk Brower, the defendant, along with others at Mossack Asset Management, who helped manage the money in the offshore accounts after the accounts were established. 6. At all times relevant to this indictment, Ramses Owens, aka Ramses Owen Saad, and Dirk Brower, the defendants, assisted US taxpayer clients of Mossack Fonseca, including US taxpayer clients in the Southern District of New York, in defrauding the IRS by concealing the client's assets and investments and income generated by those assets and investments from the IRS.
If these allegations are true, this would be an infringement not only of FATCA, but also of the forthcoming mandatory disclosure rules.
Page 3. The relevant reporting obligations of the United States taxpayers. 7. The IRS is an agency of the United States Department of Treasury, responsible for administering and enforcing the tax laws of the United States and collecting the taxes owed to the Treasury of the United States. 8. United States citizens, resident aliens, and legal permanent residents, collectively US taxpayers, are obligated to file a US individual income tax return, Form 1040, with the IRS, reporting their worldwide income for each year if their gross income for the tax year exceeded a threshold amount. On Form 1040, the US taxpayer must also report all capital gains, e.g. profits from the sale of stock or real estate, which he or she has received. These requirements apply equally to income and capital gains earned abroad, on which US taxpayers are obliged to pay US taxes. 9. In addition, on Schedule B of Form 1040, the US taxpayer must indicate whether, at any time during the relevant calendar year, he or she had an interest in or signature or other authority over a financial account in a foreign country, such as a bank account, securities account, or other financial account. If the US taxpayer answers the question in the affirmative, then the US taxpayer must indicate the name of the particular country or countries in which the account is or the accounts are located. Page 4. 10. Separate and apart from the obligation to file Forms 1040 that report all income and capital gains, US taxpayers who have a financial interest in or signatory authority over a financial account in a foreign country with an aggregate value of more than $10,000 at any time during a particular calendar year are required to file with the United States Department of Treasury a report of foreign bank and financial accounts, FinCEN Report 114, formerly TDF 90-22.1 F-bar. At all times relevant to this indictment, the F-bar for any calendar year was required to be filed on or before June 30th of the following calendar year. In general, the F-bar requires that the US taxpayer filing the form identify the financial institution at which the financial account is held, type of account, bank, securities or other, the account number, and the maximum value of the account during the calendar year for which the F-bar is being filed. 11. When a US taxpayer beneficially owns a bank account, securities account, or other financial account that is maintained outside of the US, but fails to disclose the account or the income generated in the account on Schedule B of Form 1040 or an F-bar, the account is referred to as an undeclared account.
Now, if undeclared accounts are one of the main reasons for the existence of the FATCA regime, one could argue that FATCA still has some way to go. And that is because many financial institutions have still got many tens of thousands of accounts that they haven't classified for FATCA and for CRS. And I talk about this at great length on the video called Undocumented Accounts, and I illustrate why very few financial institutions are actually compliant with FATCA, that is, and also with CRS. So I would say if undeclared accounts are the real issue, that FATCA still has some way to go, because a lot of undeclared accounts are still concealed simply because they haven't been classified for FATCA and for CRS, and because they haven't been classified, they haven't been reported.
Page 5. At all times relevant to this indictment, a federal tax was imposed on the transfer of the taxable estate of every dissident who was a US taxpayer and whose gross estate, plus adjusted taxable gifts and specific exemptions, was more than $5,450,000 US. 13. At all times relevant to this indictment, the IRS's Offshore Voluntary Disclosure Program, OVDP, was a voluntary disclosure program specifically designed for US taxpayers with exposure to potential criminal liability and/or substantial civil penalties due to a willful failure to report foreign financial assets and pay all tax due in respect of those assets. As part of their participation in the OVDP, US taxpayers have immunity from criminal prosecution so long as they cooperate fully and truthfully with the IRS and pay all back taxes due, along with interest and penalties.
There's an important point here about the OVDP. The OVDP was a voluntary disclosure program specifically designed for US taxpayers with exposure to, and here's the very important bit, potential criminal liability and/or civil penalties due to a willful failure to report foreign financial assets and pay all taxes due in respect of those payments. So not every single client should be advised to enter into the OVDP. The OVDP is specifically for people with potential criminal liability and/or substantial civil penalties due to a willful failure. That simply isn't true of every US account, every account you have with a person who holds US citizenship. Just because you find somebody with US citizenship doesn't mean they're a tax evader. And certainly anyone should think carefully about advising that person to join the OVDP without carefully understanding the fact pattern.
The conspiracy. 14. From at least in or about 2000 through in or about 2017, Ramses Owens, aka Ramses Owen Saad, and Dirk Brouwer, the defendants, conspired with each other and with others known and unknown to help US taxpayer clients of Mossack Fonseca conceal assets and investments and the income generated by those assets and investments from the IRS through fraudulent, deceitful and dishonest means. Page 6. Means and method of the conspiracy. 15. Among the means and methods by which Ramses Owens, aka Ramses Owen Saad, and Dirk Brouwer, the defendants, and their co-conspirators would and did carry out the conspiracy were the following. A. In order to conceal their clients' assets and income from the IRS, Owens and Brouwer aided, assisted, advised, facilitated the establishment of, maintained and managed undeclared assets on behalf of US taxpayers who were clients of Mossack Fonseca.
If these allegations are true, this would have to be the most egregious example of non-compliance with FATCA and illustrates what FATCA was actually designed to do.
B. Owens and Brouwer created, marketed, sold and serviced sham foundations and shell companies formed under the laws of countries such as Panama, Hong Kong and the British Virgin Islands, BVI, to conceal from the IRS and others the ownership by US taxpayers of accounts established at overseas banks as well as the income generated in those accounts. Page 7. The sham foundations were one of the primary products marketed by Owens and Brouwer at Mossack Fonseca. Mossack Fonseca advertised the sham foundations as including asset protection and privacy.
This is precisely the sort of thing that is no longer allowed under the mandatory disclosure regime.
Owens also advised clients that the sham foundations provided tax benefits in multiple jurisdictions, including the United States. As structured by Mossack Fonseca, the sham foundations typically owned the shell companies that nominally held undeclared assets on behalf of the US taxpayer clients of Mossack Fonseca. D. The sham foundations and related shell companies were incorporated in various foreign countries and typically held one or more bank accounts in different foreign countries. The names of Mossack Fonseca's clients generally did not appear on the incorporation paperwork for the sham foundations or related shell companies, and the clients typically did not have signature authority on associated bank accounts. However, the clients beneficially owned the assets in the bank accounts. E. The clients were instructed by Owens, Brower and others to transfer their assets, typically real property and bank accounts, to the sham foundations and related shell companies in order to conceal their true ownership from the US government and other interested parties, including creditors. 8. F. Although the clients transferred ownership of their assets into the names of the sham foundations and related shell companies, which had nominee officers and directors provided by Mossack Fonseca, the clients continued to have complete access to the assets and complete control over the assets. G. To continue assisting with the concealment of the client's assets, and in exchange for additional fees, Owens & Brower provided support to the clients who had purchased the sham foundations and related shell companies by providing corporate meeting minutes, resolutions, mail forwarding, and signature services. H. In order to conceal assets and income from the IRS, Owens & Brower aided, assisted, advised, and facilitated the transfer of the client's funds to the undeclared bank accounts nominally held by the shell companies. I. Owens & Brower purposefully established the bank accounts in locations with strict bank secrecy laws which impeded the ability of the United States to obtain bank records for the accounts. J. In certain cases, Owens & Brower met with US taxpayer clients of Mossack Fonseca within the Southern District of New York and elsewhere to solicit and maintain clients for Mossack Fonseca by falsely representing that the taxpayers could lawfully avoid paying income taxes by placing their income and assets in the names of the various shell companies and sham foundations.
Well, it simply isn't true that the client could lawfully avoid paying income taxes by doing this.
K. Owens & Brower caused US taxpayer clients of Mossack Fonseca to travel outside the United States to destinations including Switzerland, Panama, the Bahamas, and Costa Rica to provide banking services and investment advice related to their undeclared accounts. L. Owens & Brower instructed US taxpayer clients of Mossack Fonseca about how to repatriate funds to the United States from their offshore bank accounts in a manner designed to keep the undeclared accounts concealed. Among other things, Owens & Brower instructed clients to use direct debit cards and fictitious sales to repatriate their funds covertly. M. US taxpayers who conspired with Owens & Brower filed false and fraudulent Forms 1040, which, among other things, failed to report their interest in their undeclared accounts and the income generated in their undeclared accounts. N. Certain US taxpayers who conspired with Owens & Brower failed to file FBARs identifying their undeclared accounts. Owens & Brower's US taxpayer clients at Mossack Fonseca. 16. At various times relevant to this indictment, Ramses Owens, aka Ramses Owens Saad, and Dirk Brower, the defendants, carried out the means and methods of the conspiracy with respect to various US taxpayer clients of Mossack Fonseca. Details for several examples of those US taxpayer clients, who are only a subset of the US taxpayer clients of Mossack Fonseca, with whom Owens and Brower unlawfully conspired, are set forth more fully below. Client 1, 17. Client 1 is a US citizen. Client 1 grew up in the United States and currently lives in Manhattan. 18. In or about 2001, when Client 1 was approximately 33 years old, Client 1 moved to London, United Kingdom. In London, Client 1 worked as a liaison between investors and financial managers and earned fees when a potential investor, whom Client 1 introduced to a financial manager, made an investment. 19. While in London, Client 1 decided to open an offshore trust to hold the money that Client 1 was earning. Client 1 was referred to Ramses Owens, aka Ramses Owens Saad, the defendant, for assistance in creating such a trust. 20. Thereafter, Client 1 met with Ramses Owens, aka Ramses Owens Saad, the defendant, at Mossack Fonseca's headquarters in Panama. Owens explained to Client 1 the manner in which he would set up the trust for Client 1. Shortly after this meeting, Owens opened 2 offshore bank accounts for Client 1 at a bank located on the Isle of Man. 2 offshore accounts on the Isle of Man were nominally held by 2 offshore shell companies which were formed by the Mossack Fonseca, conducted no real operations, and existed solely for the purposes of holding Client 1's offshore accounts. Client 1 selected the names of the 2 shell companies at the instruction of Owens. Owens also formed 2 offshore sham foundations for Client 1, which Client 1 understands were the owners of the 2 shell companies that nominally held Client 1's accounts on the Isle of Man. 21. Initially, Client 1 deposited approximately $1 million in value, which Client 1 had earned from Client 1's job, into 2 offshore bank accounts on the Isle of Man. Over time, Client 1 continued to deposit Client 1's earnings into these accounts, making additional deposits that totaled approximately several million US in value. 22. Ramses Owens, aka Ramses Owens Saad, the defendant, who held himself out as an international tax expert and who was aware that Client 1 was a US citizen, falsely advised Client 1 that Client 1 would not have to report any of his income to the IRS, so long as Client 1 did not invest in US securities, US real estate, or anything related to the United States. Owens never told Client 1 that Client 1 was obligated to report the existence of Client 1's foreign bank accounts and income that Client 1 earned on Client 1's foreign investments, as Owens well knew that Client 1 was legally required to do. Client 1 relied on Owens' advice. Page 12. In or around 2005, Ramses Owens, aka Ramses Owens Saad, the defendant, moved Client 1's money from the 2 offshore accounts at a bank on the Isle of Man to an offshore account at a bank located in Hong Kong. The offshore account in Hong Kong was nominally held by a new offshore shell company which was formed by Mossack Fonseca, conducted no real operations, and existed solely for the purpose of holding Client 1's offshore account in Hong Kong. Client 1 chose the name of the shell company at Owens' instruction. Mossack Fonseca also formed a new offshore sham foundation for Client 1. At or around that time, Client 1 moved back to the United States on a permanent basis. 24. In or around the fall of 2008, Client 1 met with Ramses Owens, aka Ramses Owens Saad, and Dirk Brouwer, the defendants, at a hotel in Manhattan. During the meeting, Owens introduced Client 1 to Brouwer. Brouwer told Client 1, in sum and substance, that Brouwer was going to make money for Client 1 by making certain investments with Client 1's offshore assets. During the meeting, Client 1 told Owens, in sum and substance, that Client 1 was interested in entering the OVDP and disclosing Client 1's offshore bank account to the IRS so that Client 1 could bring Client 1's offshore money back to the United States. 25. At this meeting, Ramses Owens, aka Ramses Owens Saad, the defendant, told Client 1, in sum and substance, that joining the OVDP would not be necessary. Instead, Owens recommended that Client 1 speak with Richard Gaffney, aka Dick Gaffney, who is charged as a defendant in other counts of this indictment. Gaffney, at all times relevant to this indictment, was a partner at a US-based accounting firm, the US accounting firm. Owens stated to Client 1, in sum and substance, that Gaffney was an international tax accountant based in the United States, and that Gaffney could assist Client 1 in repatriating the money to the US without having to disclose Client 1's offshore bank account in Hong Kong to the IRS. 26. On or about November 7th, 2008, Client 1 met with Gaffney at a train station in Boston, Massachusetts. During that meeting, Client 1 told Gaffney that Client 1 wanted to bring Client 1's offshore money back to the United States. In response, Gaffney told Client 1, in sum and substance, that there were different ways to accomplish that goal, including by putting the money into artwork or real estate, or by selling a real or made-up company. At the time, Client 1 did not agree to pursue any of these ideas because Client 1 was still interested in entering the OVDP. 27. In or about February 2009, Client 1 had another meeting with Ramses Owens, aka Ramses Owens Saad, the defendant, in Panama. At that time, Client 1 again told Owens, in sum and substance, that Client 1 wanted to enter the OVDP. Owens reiterated that entering the OVDP would not be necessary and that Client 1 should not do it. Owens asked whether Client 1 had spoken with Gaffney, and Client 1 relayed to Owens that Gaffney had told Client 1. Owens had follow-up questions for Gaffney regarding how the money could be repatriated through the sale of a company, and specifically, Owens wanted to know whether Client 1 would have to pretend to sell all of the company or just some of it. Client 1 wrote down Owens' questions and subsequently asked Gaffney for the answers to them. Gaffney, in response, provided additional guidance to Client 1 about how Client 1 could continue to conceal Client 1's offshore account by creating a fictitious company sale. 28. Thereafter, in or around 2009, Client 1 followed the advice of Gaffney and Ramses Owens, aka Ramses Owens Saad, the defendant, and covertly repatriated approximately $3 million of Client 1's offshore money to the United States. Client 1 was able to repatriate that money covertly by falsely stating on Client 1's 2009 federal tax return that the money was the result of a sale of a company, even though in truth it was not. After Client 1 repatriated approximately $3 million US in this manner, approximately $1 million US still remained in Client 1's offshore account, the existence of which Client 1 continued to conceal from the IRS. 29. At the time the offshore money was repatriated to the United States, Client 1's offshore account was located at a bank in Switzerland because Mossack Fonseca had moved Client 1's money to Switzerland from Hong Kong. Ramses Owens, aka Ramses Owen Saad, the defendant, arranged to have Client 1's approximately $3 million US repatriated by wiring it from the bank in Switzerland to a domestic bank account held by Client 1. 30. Client 1 did not disclose to Client 1's tax preparer the fact that, in truth, the approximately $3 million US had come from an offshore bank account and was not actually from the sale of a company. Moreover, the fictitious sale was included in Client 1's 2009 federal tax return for tax purposes, and Client 1's offshore bank account was not disclosed on that return or on Client 1's federal tax returns for other years as required by law. 31. Client 1 paid Gaffey for his advice regarding the fraudulent repatriation of the offshore money. 32. In or around late 2013, without consulting either Ramses Owens, aka Ramses Owen Saad, the defendant, or Gaffey, Client 1 entered the OVDP and reported the existence of Client 1's previously undisclosed assets to the IRS. In connection with entering the OVDP, Client 1 sought and obtained records regarding Client 1's undeclared assets from Dirk Brouwer, the defendant, and from a co-conspirator at Mossack Fonseca, who is not named as a defendant, herein CC1. At that time, in response to hearing that Client 1 was in the process of entering the OVDP, both Brouwer and CC1 asked Client 1 not to disclose their names to the IRS. Page 16. 33. On Client 1's Forms 1040 for the tax years 2001 through and including 2013, prior to entering the OVDP, Client 1 falsely and fraudulently failed to report Client 1's interest in or signature or other authority over Client 1's undeclared accounts that were opened, maintained and managed by Mossack Fonseca. Moreover, for these years Client 1 failed to file FBARs disclosing these undeclared accounts. Client 2, 34. Client 2 is Harold Joachim Vondergoltz, aka H.J. Vondergoltz, aka Johann Vondergoltz, who is charged as a defendant in other counts of this indictment. Vondergoltz is a German-born national who grew up in Guatemala and who has been a resident of the United States since approximately 1984. 35. As a resident alien of the United States, Vondergoltz is subject to US tax laws which require him to report and pay income tax on worldwide income, including income and capital gains generated in domestic and foreign bank accounts. At all times relevant to this indictment, Vondergoltz evaded these requirements by setting up a series of shell companies and bank accounts and hiding his beneficial ownership of the shell companies and bank accounts from the IRS. Vondergoltz was assisted in this scheme by Ramses Owens, aka Ramses Owens Saad, the defendant, and by Gaffey. 17. As part of this fraudulent scheme, and as discussed in greater detail below, Vondergoltz, Gaffey and Ramses Owens, aka Ramses Owen Saad, the defendant, have falsely claimed that Vondergoltz's elderly mother, the mother, is the sole beneficial owner of the shell companies and bank accounts at issue. At present, the mother is approximately 102 years old. She is a Guatemalan citizen and resident, and unlike Vondergoltz, she is not a US taxpayer. Vondergoltz's beneficial ownership of the relevant entities and assets. 37. Beginning in or around at least the 1980s, Vondergoltz used the services of Mossack Fonseca to create various foreign entities which are shell companies, the REVAC entities, for the purposes of holding unreported assets for himself in the US and abroad. The REVAC entities were initially owned by an overlying trust, the REVAC Trust, and later by an overlying foundation, the REVAC Holdings Foundation, which were also created by Mossack Fonseca. The relevant documentation regarding the REVAC Trust and the REVAC Holdings Foundation, which dates to in or about 1988, makes clear that Vondergoltz was at all times a beneficial owner of the REVAC entities, along with the other assets of the REVAC Trust and the REVAC Holdings Foundation. Page 18, 38. The REVAC Trust, domiciled in the BVI, was first formed in or about 1988. The trust agreement for REVAC Trust, the REVAC Trust Agreement, which was written with the assistance of Mossack Fonseca, stated that upon the death of Vondergoltz's father, which occurred in or about 1990, the assets in the trust were for the use and benefit of Vondergoltz. The REVAC Trust Agreement identified Vondergoltz as the trust's primary beneficiary. The REVAC Trust Agreement also identified Vondergoltz's wife and his 3 children as secondary beneficiaries. The Revac Trust Agreement made no mention of von der Goltz's mother, from whom von der Goltz's father was estranged at the time of the Revac Trust's creation. 39. Later, in or about 2007, von der Goltz used the services of Mossack Fonseca, including the services of Ramses Owens, aka Ramses Owens Saad, the defendant, to resettle the Revac Trust into the Revac Holdings Foundation, domiciled in Panama. The original regulations for the foundation, the Revac Holdings Foundation regulations, which were maintained by Gaffey in the files of the US accounting firm, identified von der Goltz as the first beneficiary of the Revac Holdings Foundation, consistent with his status as the primary beneficiary of the Revac Trust. The Revac Holdings Foundation regulations identified the other beneficiaries of the Revac Holdings Foundation as von der Goltz's wife and 3 children. The Revac Holdings Foundation regulations further identified von der Goltz as the founder and manager of the Revac Holdings Foundation, and they identified Gaffey as a substitute manager. Mossack Fonseca was identified as the resident agent, and Owens was identified as a member of the Foundation Council. Like the Revac Trust Agreement, Revac Holdings Foundation regulations made no mention of the mother. 40. The Revac Holdings Foundation provided that von der Goltz was to contribute assets to the Revac Holdings Foundation, and that these assets were to be held and owned by the Foundation. Moreover, the Revac Holdings Foundation regulations stated that, after von der Goltz's death, the Revac Holdings Foundation was to distribute between 20% and 40% of its annual income to his family members, i.e. von der Goltz's wife and 3 children, in a tax-efficient manner. At von der Goltz's insistence, the Revac Holdings Foundation regulations also cautioned that any family member engaging in reprehensible conducts or marrying an unacceptable troublemaking or gold-digging spouse can be partially or totally eliminated from receiving any benefits from the Foundation. 41. The Revac Holdings Foundation regulations further provided that von der Goltz's initial contributions to the Revac Holdings Foundation were to serve as the base for growth of the Revac Holdings Foundation, not only of the investments contributed, but also to provide liquidity for future investments in private equity, real estate, and fund investments that had been thoroughly researched and fit into the philosophy of the founder, von der Goltz. 42. The Revac Holdings Foundation, through various Revac entities, made investments of the type described in the Revac Holdings Foundation regulations, totaling tens of millions of dollars in value. For instance, the December 31st, 2012 balance sheets for the Revac Holdings Foundation and the Revac entities, which were also maintained by Gaffey in the files of the US accounting firm, listed out the entities' various investments, including investments in private equity companies, real estate investment companies, and a watch company founded by von der Goltz. The December 31st, 2012 balance sheets further reflect that as of that date, the investments made by the Revac entities had a total value of approximately $35,012,126. The evasion of von der Goltz US reporting and tax obligations. 43. Beginning in or about 2000, von der Goltz maintained bank accounts held in the names of various Revac entities, as well as the Revac Holdings Foundation, the Revac bank accounts. At all times relevant to this indictment, the Revac bank accounts, which included investment accounts as well as checking and savings accounts, were located in both the United States and abroad at various financial institutions. Von der Goltz, as the beneficiary of the Revac Trust and the Revac Holdings Foundation, and as a beneficial owner of the Revac entities, was a beneficial owner of the assets in the Revac bank accounts. However, von der Goltz used the assets in the Revac bank accounts for his personal benefit without properly reporting the assets to the IRS or paying the appropriate income taxes or income generated by the assets as he was legally obligated to do. Von der Goltz was assisted in that effort by Ramses Owens, aka Ramses Owens Saad, the defendant, and by Gaffey. 44. Ramses Owens, aka Ramses Owens Saad, the defendant, and Gaffney served as the authorised signatories on the Revac bank accounts and facilitated the opening of those accounts in a manner designed to conceal von der Goltz's beneficial ownership from the IRS. As an example, between in or about 2010 and 2013, Gaffey and Owens assisted von der Goltz in opening domestic Revac bank accounts in the name of a particular Revac entity, MJO Investments Limited, MJO, at banks in Boston, Massachusetts, and New York, New York. At all times relevant to this indictment, von der Goltz was the sole beneficial owner of MJO and the assets that MJO held. However, Gaffey and Owens did not identify von der Goltz as such when they opened these accounts at US-based banks.
So what this means is that the customer account wasn't given the correct FATCA status, a reportable FATCA status, because the underlying beneficial owner was a US citizen and hence was not reported. This is a classic example of what happens if you don't classify a customer correctly for FATCA, you get the wrong reporting outcome. The wrong outcome here was not to report a reportable US person.
Instead, Gaffey and Owens signed IRS Form W8-BEN, which must surely be more accurately a W8-BEN-E, falsely identifying to the banks that the accounts were not subject to US income tax withholding because MJO, a foreign shell company, beneficially owned the assets in the accounts. As a result, although these accounts made investments that generated income, no US income was reported or paid on the gains generated. 45. As another example, in the early 2000s, Ramses Owens Saad, the defendant, assisted Von der Goltz in opening foreign bank accounts in the names of various REVAC entities at a bank in Panama, the Panamanian Bank. In contrast to the account opening documentation supplied to the US banks described above, the account opening documentation for the Panamanian Bank identified Von der Goltz as the beneficial owner of the assets in these accounts. Owens, however, served as a director of the REVAC entities that nominally held the accounts, held signature authority over the accounts, and directed transfers to and from the accounts on Von der Goltz's behalf, including to and from places within the United States. Although the REVAC entities at Panamanian Bank held millions of dollars in assets, Von der Goltz never reported the existence of the accounts or the interest generated in the accounts to the IRS, nor did he ever file FBARs with respect to the accounts. 23. 46. Ramses Owens, aka Ramses Owens Saad, the defendant, and Gaffey discussed with each other the need to conceal Von der Goltz's beneficial ownership status in the United States. For instance, in an email to Gaffey dated June 5th, 2007, Owens proposed ways in which he and Gaffey could help Von der Goltz conceal his ownership of MJO from US companies in which MJO was an investor. Owens stated that, "I know it is not good to comment this by email, but he had been unable to reach Gaffey via phone and wanted Gaffey to see this message the soonest."
It certainly wasn't good to comment about this via email.
Owens then informed Gaffey that several US companies had requested the real and final beneficial owner of MJO,
And this is exactly what they're required to do under FATCA.
which name, as you know, we cannot disclose.
In effect, if these allegations are true, then Mossack Fonseca frustrated the purpose of FATCA.
Owens further stated that Von der Goltz's passport should not be provided as we cannot make a link between Von der Goltz and MJO inside the USA. Owens suggested providing instead the passport of the mother. Owens also stated that he had suggested to Mossack Fonseca that he, Owens, who like the mother is not a US taxpayer, be identified as the beneficial owner of MJO, but his partners at Mossack Fonseca did not like the idea. 47. Von der Goltz, as the beneficial owner of these assets, regularly benefited from the money in the REVAC bank accounts. Email correspondence shows that from at least in or about 2003 through 2016, Gaffey instructed various individuals, including individuals at Mossack Fonseca, to wire funds from various REVAC bank accounts to entities and accounts that personally benefited Von der Goltz. Gaffey repeatedly directed the payment of Von der Goltz's various personal expenses, including hunting trips, grouse shoots, art, hangar rentals, and mortgage payments, as well as the payment of purported personal loans. Bank records show that between in or about 2010 and 2016, Von der Goltz received over $1.4 million into his personal bank accounts from accounts nominally held by MJO alone. 48. On Von der Goltz Forms 1040 for the tax years 2000 through and including 2016, Von der Goltz falsely and fraudulently failed to report the income and capital gains generated in connection with the domestic REVAC bank accounts. He also falsely and fraudulently failed to report his interest in or signature or other authority over the offshore undeclared REVAC bank accounts. Moreover, for these years, Von der Goltz failed to file FBARs disclosing his beneficial ownership of the offshore undeclared REVAC bank accounts. Additional payments made to promote the scheme. 49. Von der Goltz compensated Ramses Owens, aka Ramses Owens Saad, the defendant, and Gaffey for their assistance in perpetrating this fraudulent scheme. For example, between in or about June of 2011 and June of 2014, Von der Goltz used his undeclared assets at the Panamanian Bank to make a series of payments to Owens at a new law firm, the Owens firm, which Owens joined sometime after 2010, and to Gaffey at the US accounting firm. These payments, which went from Panama to or through places in the United States, included an April 15, 2013 transfer of $110,000 to Owens at the Owens firm. This transfer, which constituted the repayment of a loan made by the Owens firm as part of the scheme, was routed through a correspondent bank in New York, New York. 50. The scheme was also promoted through a series of wire transfers from bank accounts in Panama and Switzerland to places in the United States. These wire transfers, which were sent between in or about May 2007 and July 2011, were made in order to fund capital calls for US investments. Ramses Owens, aka Ramses Owens Saad, the defendant, Gaffey and von der Goltz made these US investments through the REVAC entities rather than through von der Goltz individually, so that von der Goltz could invest in US venture capital funds and evade payment of US taxes on the capital gains. The fraud involving the Swiss bank REVAC accounts. 51. In or about November 2007, Ramses Owens, aka Ramses Owens Saad, the defendant, and Gaffey began working together to open certain REVAC bank accounts for von der Goltz at a bank in Switzerland, the Swiss bank. Those accounts were held in the name of MJO, the Swiss bank MJO account, and the REVAC Holdings Foundation, collectively the Swiss bank REVAC accounts. Owens and Gaffey determined and discussed via email that individuals other than von der Goltz would serve as signatories on the Swiss bank accounts. Ultimately, Owens, along with two other individuals, held signature authority over these accounts, which were established in or about January 2008. 52. Bank account forms for the Swiss bank REVAC accounts identified von der Goltz as the sole beneficial owner of the assets held in these accounts. Notably, these forms listed an address for von der Goltz in Guatemala, even though von der Goltz had been living permanently in the United States since approximately 1984, and Ramses Owens, aka Ramses Owens Saad, the defendant, and Gaffey were well aware that von der Goltz was a US resident. Moreover, despite the fact that the forms identified von der Goltz as the sole beneficial owner of the assets in the accounts, Owens also signed declarations of non-US status for corporations and other entities for the accounts which falsely certified that the nominal foreign account holders, i.e. the REVAC Holdings Foundation and MJO, were the beneficial owners of the accounts for United States tax purposes.
This essentially means that if the allegations are true, AW8 Benny was completed and signed, falsely declaring non-US status. This was the wrong FATCA status. It gives the customer a non-US, a non-reportable FATCA status, when in fact a reportable FATCA status would have been appropriate. Having awarded that FATCA status to that account, the account would then have been reported. Because the account was not identified as a US account and no W9 was on file with Swiss bank, no taxes were withheld. Again, this is a consequence of a failure to attribute the correct FATCA status, the correct reportable FATCA status. And this, it resulted in not withholding on that customer and not reporting that customer.
53. Email correspondence between Ramses Owens, aka Ramses Owens Saad, the defendant Gaffey, and a Swiss bank representative reveals that during the years that the Swiss bank REVAC accounts were held at the Swiss bank, von der Goltz visited the bank, met with bank representatives, and provided instructions to the bank, including instructions concerning payments that should be made from the Swiss bank MJO account. In this email correspondence, the participants repeatedly referred to von der Goltz as the beneficial owner of the Swiss bank REVAC accounts. 54. In or about May 2013, von der Goltz, with the assistance of Ramses Owens, aka Ramses Owens Saad, the defendant, altered the REVAC Holdings Foundation regulations. The new documentation, the amended REVAC Holdings Foundation regulations, listed for the first time the mother as the first beneficiary of the REVAC Holdings Foundation. As a result, the mother also became the purported beneficial owner of MJO and a purported beneficial owner of all the other REVAC entities. However, the beneficial ownership forms on the Swiss bank account REVAC accounts were not changed, and von der Goltz retained his sole financial interest in these accounts. 55. On or about June 14, 2013, shortly after the issuance of the amended REVAC Holdings Foundation regulations, von der Goltz received into a personal bank account at a bank in Boston, Massachusetts, Boston Bank, a transfer of approximately $430,000 from the Swiss bank MJO account. Email correspondence from June 13 reveals that at the time von der Goltz received this transfer from the Swiss bank MJO account, he needed to pay off an outstanding home equity line of credit at the Boston Bank. As bank records from the Swiss bank show, the funds from the Swiss bank MJO account were the result of the liquidation of shares in precious metals held by the account. However, because the account was not identified as a US account and no IRS Form W9 was on file with the Swiss bank, no taxes were withheld from any capital gains generated from the sale. Similarly, no taxes were paid on any gains generated by the sale because von der Goltz, with Gaffey's assistance as the return preparer, filed a Form 1040 for the 2013 tax year that falsely failed to report this income to the IRS. 56. Subsequently, in or about the fall of 2016, after von der Goltz became aware that he was under investigation by the US Department of Justice, von der Goltz provided the DOJ with an IRS Form 3520-3520, which is a form used to report gifts received from a foreign person. Form 3520 that Von der Goltz provided to the DOJ, which purported to cover the 2013 tax year, characterized the transfer of approximately $430,000 from the Swiss bank MJO account as a non-taxable gift from a foreign person, i.e. the mother, who is a Guatemalan citizen and resident. Page 29. As discussed above, however, this transfer was not a non-taxable tax gift from a foreign person, but rather a transfer of Von der Goltz's own money to one of his personal domestic bank accounts. Further, there is no record of Form 3520 ever having been filed with the IRS. Instead, Von der Goltz appears to have provided it to law enforcement for the first time after learning that he was under investigation for tax evasion. The false FBARs. By letter dated March 4, 2014, the Swiss bank informed Von der Goltz that, pursuant to requirements under the Foreign Account Tax Compliance Act, FATCA, and the Swiss bank program run by the DOJ, the bank had undertaken a review of its account relationships, and that, in the course of that review, the bank had identified Von der Goltz's accounts as US related because he was the beneficial owner of the accounts and had US resident status. The Swiss bank further informed Von der Goltz that the bank, in certain circumstances, could be required to report his accounts and provide his identity to the United States. In the letter, the bank encouraged Von der Goltz to enter into the IRS's OVDP and voluntarily report his accounts to the IRS himself. 58. In or about April 2014, Von der Goltz retained a US-based law firm, the US law firm, to assist him with entering into the OVDP. However, in or about September 2014, instead of entering into the OVDP, Von der Goltz filed amended FBARs for the years 2009 to 2013, the amended FBARs. The amended FBARs were prepared by Gaffey and the US law firm. 59. The amended FBARs filed by Von der Goltz were materially false. Prior to 2014, Von der Goltz had annually filed FBARs reporting his interest in 2 foreign accounts held in his personal name. However, he did not report his interest in any accounts at the Swiss bank. The amended FBARs reported that Von der Goltz had signature authority but no financial interest in the Swiss bank REVAC accounts. However, as Von der Goltz, Gaffey and Ramses Owens, aka Ramses Owens Saad, the defendant, well knew, Von der Goltz was the beneficial owner of those accounts and he did not actually have signature authority by design. Accordingly, the amended FBARs contained false statements that directly contradicted the contents of the account records from the Swiss bank. The amended FBARs also failed to include other REVAC bank accounts in which Von der Goltz held a financial interest, including the undeclared accounts at the Panamanian Bank, which the REVAC entities nominally held. Owens' proposal for how to continue the fraud in the event of the mother's death. 60. In or around November 2014, Ramses Owens, aka Ramses Owens Saad, the defendant, Von der Goltz, Gaffey, a prospective investment advisor, the investment advisor, and others met in London, United Kingdom, to discuss the REVAC Holdings Foundation. Von der Goltz informed the investment advisor that the purpose of the meeting was to provide an overview of the structure of the REVAC Holdings Foundation and the assets it held, which the investment advisor understood to be valued at approximately 30 million. 61. At the meeting in London, United Kingdom, Ramses Owens, aka Ramses Owens Saad, the defendant, gave a PowerPoint presentation. In his presentation, Owens proposed that upon the death of a mother, the REVAC Holdings Foundation be restructured to put a new foundation in place that Owens, who is not a US taxpayer, owned and controlled. Owens suggested that if the REVAC Holdings Foundation was restructured in this manner, Von der Goltz and Von der Goltz's children would be able to evade paying US taxes on the REVAC Holdings Foundation's earnings. After hearing Owens' presentation, the investment advisor expressed to Von der Goltz the investment advisor's belief that restructuring the foundation in the manner Owens had proposed, i.e. with Owens set up as the straw beneficial owner, would be illegal in the United States. Von der Goltz's false statements to the DOJ. 62. In or about early May 2016, a representative of the US law firm representative, contacted the DOJ on Von der Goltz's behalf. The US law firm representative indicated that Von der Goltz had recently appeared in news reports regarding the Panama Papers and offered to make Von der Goltz available for an interview to correct the statements that had been made about him in the press. The so-called Panama Papers story broke on or about April 3, 2016, when a global network of investigative journalists disclosed that it possessed approximately 11.5 million documents of Mossack Mossack Fonseca, which had been obtained from an unnamed source. 63. On or about May 11, 2016, shortly after contacting the DOJ on Von der Goltz's behalf, the US law firm representative followed up with an email. In this email, which the US law firm representative sent to the DOJ official in New York, the US law firm representative included a statement of facts, which purportedly described Von der Goltz's situation. The statement of facts, which was written in the first person with Von der Goltz as the speaker, falsely represented, in substance and in part, that upon the death of Von der Goltz's father in 1990, the mother became the beneficial owner of MJO and the other REVAC entities. The statement of fact further falsely represented, in substance and in part, that Von der Goltz was not the beneficial owner of MJO, that he had signature-only authority over the Swiss bank MJO account, and that he had not used MJO to hide funds from the US or other tax authorities. The email also attached copies of materially false amended FBARs, which Von der Goltz filed in 2014. Page 33. Approximately 1 week later, on or about May 19, 2016, Von der Goltz was interviewed by representatives of the DOJ, including an assistant United States Attorney for the Southern District of New York, and special agents from an IRS field office in New York. During the interview, which was also attended by the US law firm representative, Von der Goltz falsely stated, in substance and in part, that he only had signature authority over the Swiss bank MJO account and that the REVAC entities were beneficially owned by the mother. Client 3, 65. Client 3 was a US citizen and business person who passed away in or about September 2017. Prior to Client 3's death, Client 3 cooperated with the DOJ and supplied the DOJ with numerous emails and other materials documenting Client 3's long-standing relationship with Mossack Fonseca, which dates back to at least 2005. At the direction of the US government, Client 3 also participated in consensually monitored telephone calls with Dirk Brouwer, the defendant, and introduced Brouwer to an undercover law enforcement agent, the Undercover, as set forth in greater detail below. Materials documenting Client 3's relationship with Mossack Fonseca. Incorporation documents provided by Client 3 show that Mossack Fonseca created a number of shell companies for Client 3, which were incorporated in jurisdictions such as Turks and Caicos and the British Virgin Islands. In addition to supplying Client 3 with shell companies, Mossack Fonseca also provided Client 3 with nominee officers and directors for the companies. Many of the companies that Mossack Fonseca used for Client 3 were created specifically for Client 3, and at least one of the companies was a shelf company created in advance by Mossack Fonseca and kept unused on a virtual shelf until a client needed it. At the time when these shell companies were created, the share certificates were issued as bearer shares, meaning that there was no record of shareholders and whomever physically held the shares could cash them in. Mossack Fonseca also set up a sham foundation for Client 3 to serve as a shareholder of the shell companies. 68. Mossack Fonseca ultimately set up dozens of foreign bank accounts for Client 3, which were nominally held by these offshore shell companies in jurisdictions that included Panama, Switzerland and Andorra, all for the purposes of shielding Client 3's interest in these accounts and evading US taxes. After Client 3 sent money to Mossack Fonseca for deposit into these accounts, Client 3 relied on Mossack Fonseca and in particular Dirk Brouwer, the defendant, to invest the money for Client 3. Mossack Fonseca also created shell companies that were used to purchase property for Client 3 for the purpose of shielding Client 3's interest in the purchased properties and evading US taxes. One of these shell companies nominally purchased and owned a condominium in Grand Bay Towers in Panama City, the Panama City Condo. In total, over the years, Mossack Fonseca managed approximately $8 million in offshore assets for Client 3. 69. On Client 3's Forms 1040 for the tax years 2004 through and including 2016, Client 3 falsely and fraudulently failed to report Client 3's interest in or signature or other authority over any of the undeclared accounts that Mossack Fonseca opened, maintained and managed for Client 3. Email correspondence provided by Client 3 documents the role of Mossack Fonseca and the roles of Dirk Brouwer and Ramses Owens, aka Ramses Owens Saad, the defendants, in providing Client 3 with the tools to conceal millions of dollars in assets offshore. For example,
now here you have a situation where a financial institution is conducting no FATCA customer due diligence whatsoever, and an intermediary has discovered this and is pushing clients that way precisely because the financial institution in question is doing no FATCA CDD. This is an example of how a failure to do FATCA CDD could give some financial institutions an unfair competitive advantage. It should, however, be borne in mind that this happened on July 5th, 2005, and that FATCA was only passed into law in March 2010, and that only became effective in 2014.
A. In a July 5th, 2005 email exchange, a former employee of Mossack Fonseca, who is a co-conspirator not named as defendant here in CC2, informed Client 3 that CC2 had found a bank that seemed to be exactly what we're looking for. No W8 forms, no beneficial owner signatures, no presence in the US. Client 3 advised CC2 to open an account at that bank ASAP in the name of one of the shell companies that Mossack Fonseca had created for Client 3. B. In a March 13th, 2006 email copying Owens, CC2 told Client 3 in substance and in part that CC2 would prefer to create a private trust company for Client 3 in Turks and Caicos because, unlike the BVI, Turks and Caicos did not have a tax, information and exchange agreement with the United States. C. In a February 15th, 2008 email, Brower proposed that Client 3 set up a bank account in Monaco because Monaco has strict confidentiality and banking secrecy rules and is an exclusive and off-the-screen place for private banking. D. In a March 17th and 18th 2008 email exchange, Brower and Client 3 discussed setting up a confidential debit card for Client 3 through one of the foreign banks. E. In or about April 2008, as reflected by a series of emails, Client 3 had a meeting in Florida with Brower, Owens and Client 3's son, Client 4, to discuss the undeclared accounts that Mossack Fonseca was managing for Client 3 and Client 4. F. In a July 3rd, 2008 email, Brower forwarded Client 3 a newspaper article regarding the DOJ's investigation of the Swiss bank UBS AG, UBS, for helping Americans evade tax. G. In a December 4th, 2008 email, Brower, copying Owens, told Client 3, in substance and in part, that it appeared Liechtenstein would sign a tax treaty with the United States, but that Monaco and Andorra had not signed a treaty so far. H. In a January 6, 2010 email, Brower, copying Owens, told Client 3, in part, that using an insurance wrapper may be another alternative which may be used in the future for enhanced legal safety of offshore investment portfolios. In the wake of the public investigation of UBS, US taxpayers in Switzerland frequently attempted further to conceal their undeclared assets by using insurance wrappers. I. In March 2010, Congress passed the Foreign Account Tax Compliance Act, FATCA, which imposed additional requirements on foreign banks to search their records for US taxpayers and to report the assets and identities of such persons to the United States Department of Treasury. Shortly thereafter, in an email to Client 3 dated April 7, 2010, copying Brower, Owen stated that with respect to this new law and consequences, the jurisdictions facing more trouble will be the ones with a tax information exchange treaty in force and regularly effective with the USA. Owens further stated that we should not panic as the law would be very difficult to put in practice as many countries would strongly object.
And in point of fact, many countries did. The first country to sign up to the FATCA intergovernmental agreements was the UK, and from memory that was around December 2012. And the reason that the UK did it was because the UK had a similar problem to the US with tax evasion, largely through the UK's own crown dependencies and overseas territories. And so the UK implementing its own version of FATCA, which was called CDOT, Crown Dependencies and Overseas Territories, was based on FATCA. So the UK signed up so that it could emulate the same model and raise tax revenue. What's quite clear here is that Mossack Fonseca didn't foresee the IGAs and the number of jurisdictions, 113 at the time of recording, that would sign up to these IGAs.
Moreover, Owens advised that if we would like to be completely protected, in essence, no direct bank account or securities investment should be made with no bank whatsoever, in which case insurance policies, life, pension or similar, or real estate direct investments would be the road to take. In our case, life insurance policies wrapper would be a path to take. J. In a January 21, 2016 email, Brower told Client 3, in substance and in part, about certain banks in the Bahamas, including a particular bank which has been extremely aggressive, taking on the disposed client base from the Swiss names, particularly the non-declared European client base, as well as US clients. Brower further recommended another bank in the Bahamas as a safe harbour for the recently freed funds of your real estate sale. The real estate sale referenced by Brower in his email was the sale of the Panama City condo for approximately $275,000. Brower's efforts to continue the scheme following the breaking of the Panama Papers story. 71. As noted above, the Panama Papers story broke in the news on or about April 3rd, 2016. At that time, Client 3 continued to maintain approximately $7.3 million US in assets offshore with Mossack Fonseca. As reflected in email and telephone correspondence between Client 3 and Dirk Brower, the defendant, Client 3 had difficulty accessing Client 3's money after the Panama Papers story broke because the signatories on those accounts were nominee directors provided by Mossack Fonseca. Accordingly, Client 3 and Brower began to discuss how to move Client 3's money from the then existing accounts to new accounts so that Client 3 could access the money. Brower suggested the creation of a new sham foundation that would hold new shell companies, which in turn would hold new bank accounts. Many of the communications between Brower and Client 3 concerning the process were through a personal email account used by Brower. Brower and Client 3 also had phone communications about this topic. 73. In 2016 and 2017, during the course of these discussions between Dirk Brower, the defendant, and Client 3 received in the United States two $50,000 checks from Mossack Fonseca. As reflected in email correspondence, these checks represented a portion of the proceeds of the sale of the Panama City condo. The first of these checks was issued by a bank headquartered in the United Arab Emirates. The check reflects on its face that it was drawn on a branch of that bank in New York, New York. The second check was issued by another bank headquartered in the United Arab Emirates. The check reflects on its face that it was drawn on a branch of a US bank in New York, New York. Brower assisted in the transmission of each of these checks to Client 3. Client 3's proactive cooperation. 74. In or about January 2017, Client 3 started cooperating with the Department of Justice. After Client 3 started cooperating, Client 3 continued to communicate with Dirk Brower, the defendant, but began to do so at the direction of law enforcement. 75. The discussions that took place between Client 3 and Dirk Brower after January 2017 included, among other things, references to tax evasion as one of the historical purposes for Client 3's accounts with Mossack Fonseca. For instance, in a February 13, 2017 call between Brower and Client 3, which was recorded with Client 3's consent and contemporaneously monitored by law enforcement, Brower and Client 3 had the following exchange in substance and in part, in which Client 3 reiterated a desire to pass Client 3's offshore assets onto Client 3's children without anyone paying taxes, including US estate taxes, on the money after Client 3's death. Client 3, how are you setting up the new account? How are you setting that up? You've got a new corporation and new lawyers. Brower, exactly, a new foundation. Client 3, can you set it up the way it was originally, where if I and my wife should pass on, I want to make sure everything can go to my children tax-free? Brower, yes, it can be very simple distribution. I will talk to the lawyer that she makes a very simple to ask that you can look and if service is okay because it has to be done. It's important. Client 3, okay. Brower, we are basically closing to have such account at a bank in the Bahamas and we are also and a bank in Andorra. We're actually telling her. So I think that at least the two. And once it gets ready, I am also thinking about these guys in Antigua. I'm not so sure, but I prefer the guys in the Bahamas and then the bank in Andorra to do unintelligible. Client 3, okay. Brower, and then we can distribute the assets among them. 76. On or about June 23rd, 2017, at the direction of law enforcement, Client 3 introduced Dirk Brower, the defendant, to the undercover at a meeting between Client 3, Brower, and the undercover in the Bahamas. The meeting was monitored and recorded by law enforcement. The undercover posed as a US financial advisor to Client 3. At the end of the meeting, after Client 3 had left, the undercover told Brower, in sum and substance, that the undercover had additional US clients who, like Client 3, wanted to open offshore bank accounts and invest in offshore properties for the purpose of evading United States income taxes, including any potential inheritance or estate taxes. The undercover also pitched to Brower the idea of laundering money for US clients who had been involved in a pump and dump securities fraud scheme. Brower stated, in substance and in part, that he would be able to assist the undercover's US clients in setting up offshore companies and bank accounts to accomplish these goals. Brower also stated that he and the undercover speak further about the matter over another one of Brower's personal email accounts. 77. Thereafter, Dirk Brower, the defendant, and the undercover communicated for several weeks over Brower's personal email account and over the phone to discuss further details of a potential deal between them. During one of those telephone calls on or about July 31st, 2017, which began with Brower indicating that he preferred to speak via Skype or WhatsApp because those communication mediums are a little more discreet than the telephone, Brower proposed having the undercover's US clients send money overseas and setting up fake investment for them. Then Brower could create a fake loss to the clients from the investment so that if anyone questioned where the money had gone, it would look like the money had been placed in an investment that had done poorly. Brower stated, in sum and substance, that after he created the fake loss for the money, he and the undercover could move the money back to the United States for the undercover's US clients without the IRS discovering it. Under this proposal, as explained by Brower, the heirs of the US clients would also be free of any inheritance issues. Client 4. Client 4, who is the son of Client 3, is a US citizen who resides in Florida. 79. Client 4 was first introduced to Mossack Fonseca in or about January 2005 when Client 4 travelled to Panama with Client 4's parents, Client 3 and Client 3's wife, for vacation. While in Panama, Client 3 and Client 3's wife brought Client 4 to Mossack Fonseca's headquarters, where they met with Ramses Owens, aka Ramses Owens Saad, the defendant and CC2. 80. At this initial meeting, Ramses Owens, aka Ramses Owens Saad, the defendant and CC2 told Client 4 that CC3 was investing offshore with Mossack Fonseca and that Mossack Fonseca was providing Client 3 with a sham foreign corporation and several offshore shell companies. Owens and CC2 explained that the sham foundation controlled the shares in the offshore shell companies, which were the account holders on Client 3's offshore accounts, and provided Client 3 with privacy and security. Owens and CC2 suggested that upon the death of Client 4's parents, Client 4 should reach out to Mossack Fonseca to receive money from the sham foundation that would be characterised as offshore income, which would make it appear as though Client 4 was working for the foundation even though, in truth, Client 4 was not. Owens and CC2 told Client 4 that as a US taxpayer, if Client 4 were living outside the United States, Client 4 could exclude from Client 4's taxable income a large amount of this fake offshore income each year. Owens and CC2 also suggested that they could issue Client 4 debit or credit cards, which Client 4 could use to charge expenses to the foundation and falsely claim as business expenses on Client 4's tax returns. Page 44. 81. Several days later, Client 4 returned to Mossack Fonseca's headquarters. During the follow-up visit, CC2 introduced Client 4 to Dirk Brower, the defendant, whom Client 4 understood to be a stockbroker or investment advisor. CC2 also gave Client 4 access to Mossack Fonseca's internal website, the internal website, and asked Client 4 to use only that website to communicate with them. Client 4 was given the code name Sun and the password Sun0003 to access the internal website and to communicate with people at Mossack Fonseca in a manner that was private and secure. Subsequently, after leaving Panama, Client 4 began to communicate with Ramses Owens, aka Ramses Owens Saad, and Dirk Brower, the defendant CC2, and others at Mossack Fonseca over the internal website under the codename Sun and over the phone. These discussions included communications about the possibility of Client 4 investing Client 4's own money with Mossack Fonseca. 82. In or about January 2006, Client 4 returned to Mossack Fonseca's headquarters in Panama and met again with Ramses Owens, aka Ramses Owens Saad, the defendant, and CC2. At that time, Owens and CC2 successfully convinced Client 4 to invest Client 4's own money with Mossack Fonseca. Owens convinced Client 4 to elect a setup whereby Client 4 would send Client 4's money to Mossack Fonseca and thereafter nothing would be in Client 4's name. According to Owens, by electing this setup, Client 4 would be shielded from litigation by creditors and would be able to evade Client 4's reporting and tax obligations in the United States. Owens suggested that Client 4 should take steps to protect Client 4's money by sending it to Mossack Fonseca. 83. Thereafter, between in or about 2006 and 2008, Client 4 sent approximately $1.6 million of Client 4's money to Mossack Fonseca in a series of separate transactions, which included cashier's checks and wire transfers. As reflected in bank documents, these wire transfers, which sometimes went to an escrow account and other times went through one of Client 3's bank accounts, included a wire transfer of approximately $418,790 in August 2006, a wire transfer of approximately $152,000 in December 2006, and a wire transfer of approximately $125,000 US in December 2007. Client 4 also retained copies of some of the cashier's checks that Client 4 sent to Mossack Fonseca, which Client 4 made out in amounts less than $10,000 US, each in an attempt to avoid IRS scrutiny. Moreover, in at least one small email exchange over the internal website between Client 4 and Ramses Owens, aka Ramses Owens Saad, and Dirk Brouwer, the defendants, Brouwer referred to Client 4 sending money to Mossack Fonseca via cashier's checks in an effort to avoid leaving a track. 84. Mossack Fonseca invested Client 4's money in bank accounts that it set up at offshore banks in Panama, Andorra and Switzerland. These bank accounts, by Mossack Fonseca's design, were nominally held by offshore shell companies. These shell companies and the assets in the bank accounts were in turn wholly owned by a sham Panamanian foundation, which Mossack Fonseca also established. Ramses Owens, aka Ramses Owens Saad, the defendant, told Client 4, in sum and substance, that upon Client 4's death, Client 4's children would be able to receive tax-free money from the sham foundation, which would disguise the nature of the distributions to the children by falsely characterising the distributions as income and/or business expenses. 85. Once Mossack Fonseca was managing money for Client 4 spoke with Dirk Brouwer, the defendant, periodically over the phone and via email about how the money was being invested. Even though Client 4's name was not on the documentation, Client 4 discussed investments with Brouwer and chose different investment options based on Brouwer's suggestions. At all times, the money remained Client 4's, even though on paper Client 4 had given it to the sham Panamanian Foundation. 86. In addition to the meetings in Panama discussed above, Client 4 met with employees of Mossack Fonseca on at least one occasion in the United States. The meeting in the United States took place in or about April 2008 at a restaurant in Florida and was attended by Ramses Owens, aka Ramses Owens Saad, and Dirk Brouwer, the defendants, Client 3 and Client 4. At this meeting, the participants discussed different investment options for the undeclared money Mossack Fonseca was managing for Client 3 and Client 4. Brouwer stated, in sum and substance, that there were particular bonds that Client 3 and Client 4 could not invest in because they would have to register the bonds with the United States and it would involve too much US oversight. Owens and Brouwer also stated that they were planning to visit at least one other American client on the same trip, but remarked, in sum and substance, that they do not like having American clients because the United States had too many regulations. 87. In or about 2011, Client 4 decided to terminate Client 4's relationship with Mossack Fonseca. Client 4 spoke about this decision with CC1, who had replaced Ramses Owens, aka Ramses Owens Saad, the defendant, as the primary attorney on Client 4's accounts when Owens left Mossack Fonseca to start his own law practice at Owens' firm. CC1 expressed unhappiness at Client 4's decision to withdraw Client 4's offshore money from Mossack Fonseca. CC1 told Client 4 that Client 4 needed to get permission from the foundation to send back the assets. CC1 then refused to wire the money back to Client 4 in the United States to any account held in Client 4's own name. CC1 suggested that Client 4 create mirrored versions of shell companies in the US, the mirrored companies, and that Mossack Fonseca could then send the offshore money to bank accounts in the United States that were nominally held by the mirrored companies. CC1 further advised Client 4 that the mirrored companies should be incorporated in different states, not including the state where Client 4 lived, and that they should have nominee directors so that Mossack Fonseca and Client 4 would be protected from disclosure. 88. Accordingly, on the advice and instructions of CC1, Client 4 created the mirrored companies. However, Client 4 ultimately did not open bank accounts in the United States in the names of the mirrored companies because doing so would have required Client 4 to give Client 4's name to the US banks where the accounts were opened. Instead, Client 4 and CC1 agreed to disguise the source of the offshore money by using mirrored companies to lend money to people who were buying homes as part of Client 4's real estate business. Through this arrangement, Mossack Fonseca was able to send Client 4's offshore money back to the United States in a series of approximately 20 different transactions by routing the money through the trust accounts of the attorneys handling the closings on the homes. The mirrored companies, in turn, held the notes on the loan transactions. CC1 stressed the importance of sending the offshore money back through attorneys so that Mossack Fonseca and Client 4 would be shielded by attorney-client privilege. 89. Client 4 falsely and fraudulently failed to report Client 4's interest in or signature or authority over Client 4's undeclared accounts with Mossack Fonseca, which Client 4 maintained in or about 2006 through in or about 2011. Moreover, for those years, Client 4 failed to file FBARs disclosing these undeclared accounts. Client 5. Client 5 is a US citizen who currently lives in London, United Kingdom. 91. In or about 1995, Client 5's accountant in the United Kingdom created a shell company for Client 5. The shell company was the nominal holder of foreign bank accounts at a bank in the United Kingdom. The company was set up to shelter Client 5's income from US taxes until Client 5 needed it in retirement. After a series of disagreements with the accountant and a subsequent accountant, Client 5 sought new management of the company and was referred to Mossack Fonseca. 92. In or about 2008, Client 5 met with a former partner of Mossack Fonseca, who is a co-conspirator not named as a defendant herein, CC3, and one of the managers of Mosfon Asset Management, who is also a co-conspirator not named as a defendant herein, CC4. CC3 suggested to Client 5 that Mossack Fonseca could take the company over and set it up as a holding company for the foreign bank account. CC3 said, in sum and substance, that Mossack Fonseca manages offshore accounts and would assign an advisor to invest the money. During the course of the meeting, Client 5 told CC3 and CC4 that Client 5 was a US citizen. CC3 and CC4 assured Client 5 that they would keep Client 5's offshore money outside of the US tax system. 93. Shortly after this initial meeting, Client 5 travelled to Mossack Fonseca's headquarters in Panama, where Client 5 met with Dirk Brouwer, the defendant, and CC1. At that time, Brouwer, CC1, and Client 5 continued the conversation that Client 5 had started with CC3 and CC4. Thereafter, Brouwer and CC1 became Client 5's points of contact at Mossack Fonseca, and Client 5 primarily communicated with Brouwer. 94. Mossack Fonseca created a new offshore shell company for Client 5, which replaced the previous shell company. In or around 2008 or 2009, Mossack Fonseca opened an account at a bank in Switzerland, which was nominally held by the new shell company. The funds in Client 5's accounts in the United Kingdom were moved to the new account in Switzerland. The new shell company was formed by a sham Panamanian foundation created by Mossack Fonseca. Dirk Brouwer, the defendant, proposed setting up the structure in this way. Later, Mossack Fonseca created a second offshore company for Client 5, which in turn was held by a second sham foundation created by Mossack Fonseca. 95. At all times relevant to this indictment, Client 5 worked as a writer, including as a writer of scripts and books. The checks that Client 5 earned while working abroad were made payable to one of the offshore shell companies that Mossack Fonseca had created. Dirk Brouwer, the defendant, invested the money contained within Client 5's foreign bank accounts, which were nominally held by the offshore shell companies, but were in truth for the benefit of Client 5. 96. Dirk Brouwer, the defendant, told Client 5, in sum and substance, to keep Client 5's hands off the structure in place, otherwise it would not work, meaning that Client 5 would have to pay US taxes if Client 5 became involved in making investment decisions. It was Client 5's understanding from Brouwer and CC1 that Client 5 could successfully evade paying US taxes if Client 5 kept a distance from the shell companies and did not repatriate this money to the United States. Employees of Mossack Fonseca also suggested to Client 5 that upon Client 5's retirement, when Client 5 was no longer earning any money, Mossack Fonseca could repatriate the money to the United States by falsely categorizing it as salary to Client 5 from one of the shell companies. 97. In or around 2012 or 2013, Client 5 received a letter from the bank in Switzerland stating that the bank was closing Client 5's undeclared account because Client 5 was a US citizen and that Client 5's information would be submitted to US tax authorities. The letter from the bank in Switzerland further advised Client 5 to enter the OVDP. Client 5 discussed this letter with Dirk Brouwer, the defendant. Brouwer told Client 5 that Mossack Fonseca had not expected Client 5's offshore account to be discovered by US authorities. Brouwer suggested that Client 5 retain legal counsel. Brouwer also said, in sum and substance, that legal issues may exist with the companies that were set up for Client 5 and that Client 5 was looking at substantial fines. 99. In or about 2013, Mossack Fonseca opened an account at an Andorran bank for Client 5, which was nominally held by one of the shell companies, and transferred Client 5's money from the bank in Switzerland to the bank in Andorra. Client 5 estimates that, at the time, the amount of money transferred was over $2 million in value. Mossack Fonseca did not consult Client 5 about the movement of Client 5's money to the Andorran bank. 100. In or about 2014, Client 5 entered the OVDP and reported the existence of Client 5's previously undisclosed accounts to the IRS. 101. On Client 5's Forms 1040 for the tax years 2008 through and including 2013, prior to entering the OVDP, Client 5 falsely and fraudulently failed to report Client 5's interest in, or signature or authority over Client 5's undeclared accounts that were opened, maintained and managed by Mossack Fonseca. Moreover, for these years, Client 5 failed to file FBARs disclosing these undeclared accounts. Page 53. Statutory allegations. 102. From at least in or about 2000 through in or about 2017, in the Southern District of New York and elsewhere, Ramses Owens, aka Ramses Owens Saad, and Dirk Brower, the defendants, together with others known and unknown, willfully and knowingly did combine, conspire, confederate, and agree together with each other to defraud the United States of America and an agency thereof, to wit, the IRS. 103. It was a part and an object of the conspiracy that Ramses Owens, aka Ramses Owens Saad, and Dirk Brower, the defendants, together with others known and unknown, willfully and knowingly would and did defraud the United States and the IRS for the purpose of impeding, impairing, obstructing, and defeating the lawful governmental functions of the IRS in the ascertainment, computation, assessment, and collection of revenue, to wit, federal income taxes. Overt acts. 104. In furtherance of the conspiracy and to effect the illegal object thereof, Ramses Owens, aka Ramses Owens Saad, and Dirk Brower, the defendants, and others known and unknown, committed the following overt acts, among others, in the Southern District of New York and elsewhere. A. On or about June 5th, 2007, Owens wrote an email to Gaffey, in which Owens stated, in substance and in part, that the passport of Von der Goltz, Client 2, should not be provided to US companies because we cannot make a link between Von der Goltz and MJO inside the USA. B. In or about April 2008, Owens and Brower met with Client 3 and 4 in Florida to discuss their undeclared overseas bank accounts. C. In or around the fall of 2008, Owens and Brower met with Client 1 at a hotel in New York to discuss Client 1's undeclared overseas bank account. D. In or around 2012 or 2013, Brower discussed with Client 5 a letter Client 5 had received from a bank in Switzerland which advised Client 5 to enter the OVDP. E. On or about January 21st, 2016, Brower wrote an email to Client 3 in which Brower recommended a particular bank in the Bahamas as a safe harbour for the recently freed funds of your real estate sale. F. In or around 2016 and 2017, Client 3, with the assistance of Brower, received from Mossack Fonseca two $50,000 checks that were drawn on banks in New York, New York. Title 18, United States Code, Section 371. Count 2. Conspiracy to commit wire fraud. Owens, Brower. The grand jury further charges 105. The allegations set forth above in paragraphs 1 through 101 are re-alleged and incorporated by reference as if set fully forth herein. 106. From at least in or about 2000 through in or about 2017 in the Southern District of New York and elsewhere, Ramses Owens, aka Ramses Owens Saad, and Dirk Brower, the defendants, and others known and unknown, willfully and knowingly did combine, conspire, confederate, and agree together with each other to commit wire fraud in violation of Title 18, United States Code, Section 1343, to wit, Owens and Brower participated in fraudulent schemes to help US taxpayer clients of Mossack Fonseca conceal assets and investments and the income generated by those assets and investments from the IRS. 107. It was a part and an object of the conspiracy that Ramses Owens, aka Ramses Owens Saad, and Dirk Brower, the defendants, and others known and unknown, willfully and knowingly, having devised and intending to devise a scheme and artifice to defraud and for obtaining money and property by means of false and fraudulent pretences, representations and promises, would and did transmit and cause to be transmitted by means of wire, radio and television communication in interstate and foreign commerce, writings, signs, signals, pictures and sounds for the purpose of executing such scheme and artifice in violation of Title 18 United States Code Section 1343, Title 18 United States Code Section 1349. Count 3. Conspiracy to commit tax evasion. Owens, Gaffey, Von der Goltz. Further charges. 108. The allegations set forth above in paragraphs 1 through 101 are re-alleged and incorporated by reference as if set fully forth herein. 109. From at least in or about 2000 through in or about 2016, in the Southern District of New York and elsewhere, Ramses Owens, aka Ramses Owens Saad, Richard Gaffey, aka Dick Gaffey, and Harold Joachim Von der Goltz, aka H.J. Vondergoltz, aka Johann Vondergoltz. The defendants, together with others known and unknown, willfully and knowingly did combine, conspire, confederate, and agree together and with each other to commit offences against the United States, to wit, violations of Title 26, United States Code, Section 7201. 110. It was a part and an object of the conspiracy that Ramses Owens, aka Ramses Owen Saad, Richard Gaffey, aka Dick Gaffey, and Harold Joachim Vondergoltz, aka H.J. Vondergoltz, aka Johann Vondergoltz, the defendants, together with others known and unknown, willfully and knowingly, would and did attempt to evade and defeat a substantial part of the income tax due and owing to the United States of America by Vondergoltz in violation of Title 26, United States Code, Section 7201. Overt Acts. 111. In furtherance of the conspiracy and to effect the illegal object thereof, Ramses Owens, aka Ramses Owen Saad, Richard Gaffey, aka Dick Gaffey, and Harold Joachim Vondergoltz, aka H.J. Vondergoltz, aka Johann Vondergoltz, the defendants, and others known and unknown, committed the following overt acts, among others, in the Southern District of New York and elsewhere. A. On or about June 5, 2007, Owens wrote an email to Gaffey, in which Owens stated, in substance and in part, that the passport of Vondergoltz should not be provided to US companies because we cannot make a link between Vondergoltz and MJO inside the USA. B. On or about January 2013, Owens helped Vondergoltz open an account for MJO at a bank in New York, New York, including by sending emails to bankers in New York, New York, and did not disclose to the bank Vondergoltz's beneficial ownership of MJO. C. In or about September 2014, Vondergoltz, with the assistance of Gaffey, filed amended F-bars that were materially false and incomplete, in that they falsely stated that Vondergoltz had signature authority but no financial interest in the Swiss bank Revac accounts, and omitted other Revac bank accounts in which Vondergoltz held a financial interest. D. In or about November 2014, Owens proposed to Vondergoltz, Gaffey, and the investment advisor that upon the death of the mother, the Revac Holdings Foundation be restructured to set Owens up as a straw beneficial owner. E. On or about May 19, 2016, during an interview conducted by representatives of the Department of Justice, including law enforcement agents from New York, New York, Vondergoltz falsely stated, in substance and in part, that he had only signature authority over the Swiss bank MJO account and that the Revac entities were beneficially owned by the mother. Title 18, United States Code, Section 371. Count 4. Wire fraud. Owens, Gaffey, Vondergoltz. The grand jury further charges 112. The allegations set forth above in paragraphs 1 through 101 are re-alleged and incorporated by reference as if set fully forth herein. 113. From at least in or about 2000 through in or about 2016. In the Southern District of New York and elsewhere, Ramses Owens, aka Ramses Owen Saad, Richard Gaffey, aka Dick Gaffey, and Harold Joachim Vondergoltz, aka H.J. Vondergoltz, aka Johann Vondergoltz, the defendants, willfully and knowingly, having devised and intending to devise a scheme and artifice to defraud, and for obtaining money and property by means of false and fraudulent pretences, representations and promises, did transmit and cause to be transmitted by means of wire, radio and television communication in interstate and foreign commerce, writings, signs, signals, pictures and sounds for the purpose of executing such schemes and artifice, to wit, Owens, Gaffey and Vondergoltz participated in a fraudulent scheme to help Vondergoltz to conceal his assets and investments and the income generated by those assets and investments from the IRS, and Owens, Gaffey and Vondergoltz transmitted and caused to be transmitted interstate and foreign wires, including emails and bank wires, for the purpose of executing this fraudulent scheme. Title 18, United States Code, Sections 1343 and 2. Count 5, Money Laundering Conspiracy. Owens, Gaffey, Vondergoltz. The grand jury further charges 114. The allegations set forth in paragraphs 1 through 101 are re-alleged and incorporated by reference as if set fully forth herein. 115. From at least in or about May 2007 through in or about June 2014, the Southern District of New York and elsewhere, Ramses Owens, aka Ramses Owen Saad, Richard Gaffey, aka Dick Gaffey, and Harold Joachim Vondergoltz, aka H.J. Vondergoltz, aka Johann Vondergoltz, the defendants, and others known and unknown, knowingly did combine, conspire, confederate, and agree together and with each other to commit money laundering in violation of Title 18 United States Code, Section 1956A2A. 116. It was part and object of the conspiracy that Ramses Owens, aka Ramses Owens Saad, Richard Gaffey, aka Dick Gaffey, and Harold Joachim von der Goltz, aka H.J. von der Goltz, aka Johann von der Goltz, the defendants, and others known and unknown, in an offence involving and affecting interstate and foreign commerce, would and did transport, transmit, and transfer, and attempt to transport, transmit, and transfer monetary instruments and funds from a place in the United States to or through a place outside the United States, and to a place in the United States from and through a place outside the United States, with an intent to promote the carrying on of specified unlawful activity, to wit, the wire fraud scheme alleged in count 4 of this indictment, in violation of Title 18, United States Code, Section 1956A2A. Title 18, United States Code, Section 1956H. Counts 6 through 9. Willful failure to file an F-bar. Gaffey, von der Goltz. The grand jury further charges. 117. The allegations set forth in paragraphs 1 through 101 are re-alleged and incorporated by reference as if set fully forth herein. 118. On or about the filing dates due listed below, in the Southern District of New York and elsewhere, Richard Gaffey, aka Dick Gaffey, and Harold Joachim von der Goltz, aka H.J. von der Goltz, aka Johann von der Goltz, the defendants, did knowingly and willfully fail to file with the United States Department of Treasury an F-bar disclosing that von der Goltz had a financial interest in, and signature and other authority over, a bank, securities and other financial account in a foreign country, to wit, foreign bank account, securities and other financial assets at the Panamanian Bank and the Swiss Bank, which had an aggregate value of more than $10,000 during each of the 3 years listed below. Count 6, calendar year 2012, due date June 30th, 2013, Bank, Panamanian Bank, Swiss Bank. Count 7, calendar year 2013, due date to file F-bar, June 30th, 2014, Panamanian Bank, the Swiss Bank. Count 8, calendar year 2014, due date to file F-bar, June 30th, 2015, Panamanian Bank. Count 9, calendar year 2015, due date to file F-bar, June 30th, 2016, the Panamanian Bank. Title 31, United States Code, Sections 5314 and 5322A. Title 31, Code of the Federal Regulations, Sections 1010, 350, 1010, 306, C and D, and 1010, 840B. Title 18, United States Code, Section 2. Count 10, False Statements, von der Goltz. The grand jury further charges. 119. The allegations set forth in paragraphs 1 through 101 are re-alleged and incorporated by reference as if set fully forth herein. 120. On or about May 11th, 2016, the Southern District of New York and elsewhere, Harold Joachim von der Goltz, aka H.J. von der Goltz, aka Johann von der Goltz, the defendant, in a matter within the jurisdiction of the executive branch of the government of the United States, did knowingly and willfully make materially false, fictitious, and fraudulent statements and representations. To wit, von der Goltz caused the US law firm representative to send an email to the Department of Justice official in New York, New York, which email attached the materially false amended F-bars that von der Goltz filed in 2014, and which email falsely stated, in substance and in part, that the mother became the beneficial owner of MJO and other REVAC entities upon the death of von der Goltz's father, that von der Goltz was not the beneficial owner of MJO, that von der Goltz had signature-only authority over the Swiss MJO account, and that von der Goltz had not used MJO to hide funds from the US or other tax authorities. Title 18, United States Code, Section 1001A2A. Count 11, False Statements, von der Goltz. The grand jury further charges. 121. The allegations set forth in paragraphs 1 through 101 are re-alleged and incorporated by reference as if set fully forth herein. 122. On or about May 19th, 2016, in the Southern District of New York and elsewhere, Harold Joachim von der Goltz, aka H.J. von der Goltz, aka Johann von der Goltz, the defendant, in a matter within the jurisdiction of the executive branch of the government of the United States, did knowingly and willfully make materially false, fictitious and fraudulent statements, to wit, when interviewed by representatives from the DOJ, including the Assistant United States Attorney for the Southern District of New York and special agents from an IRS field office in New York, New York. Von der Goltz falsely stated in substance and in part, that he only had signature authority over the Swiss bank MJO account and that the REVEC entities were beneficially owned by the mother. Title 18, United States Code, Section 1001, A2. Forfeiture allegation as to count 2. 123. As a result of committing the wire fraud conspiracy offence alleged in count 2 of this indictment, Ramses Owens, aka Ramses Owen Saad, and Dirk Brouwer, the defendants, shall forfeit to the United States, pursuant to Title 18, United States Section 981, A1C, and Title 28, United States Code, Section 2461, all property, real and personal, which constitutes or is derived from proceeds traceable to the commission of the alleged offence in count 2, including but not limited to a sum of money in the United States currency representing the amount of proceeds traceable to the commission of said offence. Forfeiture allegation as to count 4. 124. As a result of committing the wire fraud offence alleged in count 4 of this indictment, Ramses Owens, aka Ramses Owen Saad, Richard Gaffey, aka Dick Gaffey, and Harold Joachim von der Goltz, aka H.J. von der Goltz, aka Johann von der Goltz, the defendants shall forfeit to the United States, pursuant to Title 18, United States Code, Section 981A1C, and Title 28, United States Code, Section 2461, all property, real and personal, which constitutes or is derived from proceeds traceable to the commission of the offence alleged in count 4, including but not limited to a sum of money in United States currency representing the amount of proceeds traceable to the commission of said offence. Forfeiture allegation as to count 5. 125. As a result of committing the money laundering conspiracy offence alleged in count 5 of this indictment, Ramses Owens, aka Ramses Owens Saad, Richard Gaffey, aka Dick Gaffey, and Harold Joachim von der Goltz, aka H.J. von der Goltz, aka Johann von der Goltz, the defendants, shall forfeit to the United States, pursuant to Title 18, United States Code, Section 982A1, all property, real and personal, involved in the offence alleged in count 5, or any property traceable to such property, including but not limited to a sum of money in United States currency representing the amount of property involved in said offence. Substitute asset provision. 126. If any of the property described above as being subject to forfeiture as a result of any act or omission of Ramses Owens, aka Ramses Owen Saad, Dirk Brouwer, Richard Gaffey, aka Dick Gaffey, and Harold Joachim von der Goltz, aka H.J. von der Goltz, aka Johann von der Goltz, the defendants, A. cannot be located upon the exercise of due diligence, B. has been transferred or sold to or deposited with a third party, C. has been placed beyond the jurisdiction of the court, D. has been substantially diminished in value, or E. has been commingled with other property which cannot be divided without difficulty. It is the intent of the United States, pursuant to Title 18, United States Code, Section 982B, Title 21, United States Code, Section 853P, and Title 28, United States Code, Section 2461, to seek forfeiture of any other property of the defendants up to the value of the forfeitable property described above. Title 18, United States Code, Sections 981 and 982, Title 21, United States Code, Section 853, Title 28, United States Code, Section 2461. End.
Two things then that I'd like to mention about FATCA. First thing is to do with undeclared accounts. The second thing to do with is fairness. The first thing, undeclared accounts. Well, FATCA still hasn't done its job in raising all of those undeclared accounts to the surface and reporting them. I say this because a lot of financial institutions still have a lot of financial accounts that they haven't classified for FATCA nor for CRS, and therefore haven't given them a reportable FATCA or CRS status, and therefore haven't reported them. So the problem still exists. That's the first thing. The second thing is about fairness. Now, FATCA as it's drafted is fair as long as you assume that every US person, every US citizen with an account outside the US is a wealthy person that's conducting tax evasion. The only problem with those assumptions is that they're not true. Certainly not every every US citizen living, working in a relationship outside of the US is a tax evader. They're not necessarily rich. Some of them are just people who applied their trade outside the US. Some of them are people who simply fell in love and married and went to live with their partner and now work outside of the US. Many of these people are tax resident in the countries they live in that are outside of the US, and they're paying their taxes. So I would say, well, then there's really no other way of saying it. The underlying premise of FATCA seems to be predicated on a belief that all Americans living outside of the US, or all Americans with financial accounts outside of the US, are by definition tax evaders. And of course they're not. A third thing to point out is that there's a perception in the market and amongst many holders of financial accounts, or would-be holders of financial accounts, that FATCA has in some way led directly to Americans being denied access to the financial system, so denied access to financial accounts. Now, Americans have and are actually being denied access to financial accounts. I'm certainly not denying that. What I'm saying though is that it wasn't caused by FATCA directly, nor by the IGAs. And let me explain why that is, or how that is. The concept of just turning over the details of American citizens and closing their accounts comes from the Swiss bank program. And for those of you who doubt this, have a look at the first settlement with the Swiss bank. That was UBS, and you can see there it's all in writing that they actually were required to close their accounts to US account holders. The FATCA regulation doesn't require, in the first instance, closure of accounts. What FATCA says is that you must get a FATCA status for your customer. If they're an American, you must get a W-9. And if you don't get a FATCA status for your customer, then you must solicit them for a self-certification. And if that self-certification isn't forthcoming within 90 days, then they are classified as a recalcitrant account holder. And one way to manage that recalcitrant account holder status is to close the account. That's true under the US Treasury version of FATCA, and the IGAs didn't go that far. Under the IGAs, those recalcitrant account holders are simply classified as recalcitrant account holders, and there isn't a legal requirement to close those accounts. So we are seeing unfair treatment to US citizens abroad, there's no doubt about it. But it's not caused by FATCA directly, it's caused by the settlements with the Swiss banks and by a lot of people in competitor banks. What they were doing was they asked, and this always happens, I've project managed and program managed many FATCA programs. When you see the top brass at these banks and financial institutions, the first question they would always ask is, what are my competitors doing? And they will find out. And there was a perception that people were offboarding Americans because of FATCA, and this was something that was said very much amongst senior managers and the top brass in financial institutions, but it wasn't true. The reason that these Americans were being offboarded was because that was part of the settlement 80 Swiss banks had reached with the US Department of Justice in the deferred prosecution agreements and with the Swiss bank program. And there's this belief, even today, that just offboarding Americans, denying Americans accounts, was as a direct result of FATCA. But all of this happened before FATCA was put into law, and there is nowhere in FATCA that says we must discriminate against US citizens simply because they are US citizens, and by that we mean deny them access to financial accounts. Just to reiterate, under the US Treasury version of FATCA, one option of dealing with recalcitrant account holders is to close those accounts. Under the IGAs, there's not a requirement to close those accounts. The US Treasury version of FATCA does indicate that the US Treasury or IRS will be looking for a pattern over time of the number of recalcitrant account holders going down. That concept doesn't exist in the IGAs. So how do we deal with this? Well, the main cause of this problem has to do with the US being almost unique in having citizenship-based taxation. And this means that US citizens who are tax resident in another country are treated as pariahs. One way to get around this, and it's too early to say that this will definitely work, my hope is that it will work, and I believe it might, is the very new Tax Fairness for Americans Abroad Act. It's a bill introduced late in 2018, HR 7358. And under that system, if it passes into law, a US citizen with a tax residence outside of the US would simply be able to elect not to be reportable under the US tax regime because they are a tax resident in another country. But to make this election, the US citizen has to have their tax records correct for the last 3 years. I hope you found this video useful. Don't forget to hit the subscribe button, and if there are any subjects you'd like me to discuss, let me know. Bye for now.